The image of justice is powerful, a defendant in a suit, standing before a judge and jury, the weight of the law palpable in the air. For centuries this scene has symbolized the seriousness of legal proceedings, where every gesture and word is scrutinized, and the presence of all parties in the same room underscores the gravity of the moment. But what happens when that defendant appears not in person, but on a screen, projected into the courtroom from miles away? The once familiar rituals of justice are suddenly transformed, replaced by digital connections and virtual interactions. Tyler Robinson's recent virtual court appearance has ignited a heated debate. Does a digital presence, mediated by cameras and microphones, diminish the gravity of justice? Or does it simply reflect the realities of a changing world, where technology is woven into every aspect of our lives? Critics argue that seeing a defendant on a screen dehumanizes them, making it easier for judges and juries to see a case file, not a living, breathing person. They worry that the subtle cues of body language, the emotional weight of being physically present, and the solemnity of the courtroom are lost in translation. The tradition of standing before a judge, feeling the eyes of the court upon you, is seen by many as essential to the process. It's a ritual that reinforces accountability and respect for the law. But is this tradition truly indispensable in the digital age? Others argue that virtual proceedings are a necessary evolution, especially in times of crisis or for those unable to travel. They believe that what truly matters is the legal substance, the facts, the arguments, and the rights of the defendant, not the physical location of the participants. Technology, they say, can make justice more accessible and efficient. If the defendant can participate fully, communicate with their attorney, and present their case, are their rights really at risk? Or does the virtual format simply offer a new way to ensure everyone has their day in court regardless of circumstance? The real question is whether the method of appearance changes the facts of the case, or merely our perception of them. Does seeing someone on a screen create distance, or can it foster a new kind of connection, one that's just as meaningful, if not more so, in our digital era? Tyler Robinson's case has become a flashpoint for this ongoing debate, drawing attention from legal experts, the media, and the public alike. It forces us to confront what we value most in our justice system: tradition, fairness, or adaptability. Is virtual justice a pragmatic solution to modern challenges, or a step away from the fairness and humanity that define our courts? The answer isn't simple. As technology continues to reshape our world, the courts must decide how to balance innovation with the enduring principles of justice. Why was Tyler Robinson on a screen instead of sitting in the courtroom? The answer comes down to two crucial factors: security and jury bias. In high-profile cases like this, every detail matters, and the stakes are incredibly high for everyone involved. Transporting a defendant who is at the center of public attention is not only risky, but also extremely expensive. The presence of media, potential threats, and the need for heightened security measures can turn a simple court appearance into a logistical nightmare. By allowing virtual appearances, the court can eliminate many of these risks. Defendants can participate from secure locations, reducing the chance of escape attempts, disruptions, or even targeted attacks. This approach keeps not just the defendant, but also court staff, jurors, and the public safer. There's also the issue of jury bias. When jurors see a defendant brought in wearing handcuffs or shackles, it can unconsciously influence their perception, making them more likely to assume guilt before any evidence is presented. Virtual hearings allow defendants to appear in plain clothes, free from visible restraints. This helps ensure that jurors focus on the facts of the case, not the optics, and that the presumption of innocence is preserved. Both the prosecution and the defense benefit from this setup. With fewer opportunities for procedural errors or claims of unfair treatment, there are fewer grounds for appeals and a lower risk of verdicts being overturned on technicalities. Of course, critics raise valid concerns. They worry that remote hearings can lead to lost nonverbal cues, those subtle gestures and expressions that can be crucial in a trial. Technical glitches like dropped calls or frozen screens can also disrupt proceedings and create frustration. However, experts argue that with proper training, secure technology, and updated courtroom protocols, most of these issues can be managed. Courts are investing in better equipment and procedures to ensure that communication remains clear and secure. Ultimately, the gains in security and fairness far outweigh the logistical hurdles. The process may not be flawless, but it represents a significant step forward in balancing safety with justice. It's a calculated trade-off, a conscious decision to prioritize a safer, fairer process for everyone involved. even if it means adapting to new challenges. Virtual appearances are not perfect, and they may never fully replace traditional trials. But for high-profile cases, they're increasingly seen as the best available option, offering a blend of security, fairness, and practicality. The justice system is adapting, slowly but surely, embracing technology to meet the demands of a changing world and striving to deliver justice in the safest, most equitable way possible. Before diving into the debate about virtual courtrooms, it's important to understand what a preliminary hearing actually is, and what it isn't. Many people imagine courtrooms filled with drama, passionate arguments, and a jury hanging on every word. But a preliminary hearing is a very different scene. It's not a full-blown trial, and it's not where guilt or innocence is decided. Instead, it's a crucial procedural step in the criminal justice process, designed to answer a simple but important question: is there enough evidence to justify moving forward with a criminal case? At this stage, the courtroom is often quieter, with fewer people present. The judge sits at the bench, reviewing documents and listening to the attorneys. There's no jury box filled with citizens, no dramatic cross-examinations, and no verdict at the end of the day. The focus is on the evidence, specifically whether there's probable cause to believe a crime was committed and that the defendant might be responsible. The judge alone makes this decision, not a jury. The prosecutor presents the evidence they've gathered so far, which might include witness statements, police reports, or physical evidence. The defense has the opportunity to challenge this evidence, question its reliability, or argue that it's insufficient. The defense can cross-examine witnesses and point out weaknesses in the prosecution's case, but the standard for moving forward is much lower than at trial. Unlike a trial where the prosecution must prove guilt beyond a reasonable doubt, here they only need to show there's enough evidence to continue. It's about establishing a foundation, not proving the entire case. The judge is trained to focus strictly on the facts and the law, not on theatrics or emotional appeals. Their job is to weigh the evidence impartially and decide if the case should proceed to trial. Since there's no jury present, there's no risk of prejudicing lay people with the format of the hearing, whether it's in person or virtual. The absence of a jury means the judge is the sole decision maker, and their legal training helps ensure the process remains fair, regardless of whether it's held in a traditional courtroom or over a video call. The main concern with virtual hearings is whether the defendant can participate fully and understand what's happening. As long as the defendant can see, hear, and communicate with their attorney, the hearing can fulfill its purpose. If those conditions are met, the preliminary hearing does what it's supposed to do: screen cases efficiently and fairly. Ultimately, the debate over virtual preliminary hearings is less about strict legal requirements and more about tradition, public perception, and the comfort level of everyone involved. Virtual hearings actually fit well with the procedural, fact-focused nature of these early court steps, making them a practical option in today's world. Most court appearances aren't dramatic. They're procedural and administrative. Arraignments, status conferences, motion hearings, these are the nuts and bolts of justice. The preliminary hearing is one such step, crucial but fundamentally about process. Efficiency and security often outweigh tradition for these routine hearings. Does the defendant need to be physically present for a scheduling discussion? Usually not. Virtual appearances save resources and reduce risk. Courts nationwide are embracing technology for these reasons. The Robinson case is just a high-profile example of a broader trend. This is the new reality of 21st century justice. High-profile cases come with massive costs, especially for security. Every defendant transport means officers, street closures, and big bills for taxpayers. Virtual hearings slash these costs, requiring only a secure connection and minimal staff. For the defense, heavy security can prejudice a case, leading to expensive legal battles. Virtual appearances can help avoid that, making the process fairer and less costly. Both sides want a process that's just and sustainable. The prosecution avoids wasted resources and appeals. The defense avoids prejudicial optics. Virtual hearings are a pragmatic compromise. They address security, cost, and fairness all at once. High-profile cases pressure the system. Virtual solutions help it hold up. It's a solution born of necessity. Now let's shift to a major legal showdown: Oregon versus the Trump administration. The issue: federal agents and National Guard deployed to Portland during intense protests. The Trump administration claimed it was protecting federal property and restoring order. Oregon argued this was unconstitutional overreach, inflaming tensions and violating civil rights. The state insisted policing Portland is a local job, not for unaccountable federal forces. This set the stage for a classic constitutional conflict over federalism. The legal battle dove deep into the Constitution. The Trump administration cited executive power and federal statutes to protect federal property. They argued the president can federalize the National Guard to restore order. Oregon countered with the 10th Amendment, policing is a state power. The state argued federal agents can't patrol city streets or arrest for local crimes. Oregon also invoked the 4th Amendment, citing unlawful detentions by federal agents. The lawsuit claimed these actions violated civil liberties and local authority. This wasn't just about jurisdiction, it was about the limits of federal power. Did the federal deployment work? The government said yes, order was restored, property protected. Oregon said no. The federal presence escalated conflict and drained local resources. Both sides pointed to data, but the real impact depended on perspective. Similar debates play out in other cities like Washington, D.C. over who's responsible for public safety. The Oregon case raised lasting questions. What's the federal government's role in local policing? When does protecting federal property cross into usurping local authority? These aren't abstract debates, they shape national security, city safety, and our relationship with government. The tension between state and federal power is ongoing, and Portland was a stark reminder.